Okay, it's 7 o'clock according to Microsoft, and we know they are gods. So welcome everybody. Welcome to today's session. My name is Richard Moorhead. I'm delighted to introduce today's session. We've got four really excellent papers. I'll introduce the speakers as the presentations run. So first up, we have Roger Smith and Becky Sandifer. They'll be known to many of you, and they're going to do a double act. Roger is a solicitor who, for a very long time, was director of the Legal Action Group, and now works on an excellent blog called lawtechA2j.org. If you don't know it, I thoroughly recommend that you sign up for alerts. He blogs regularly on developments all around the world. He's also a visiting prof at London South Bank Uni and an honorary one at Kent. Becky Sandifer is one of the leading researchers on access to justice in the world. She's a professor in the School of Social and Family Dynamics at Arizona State and faculty fellow at the American Bar Foundation. She won an absolutely massive grant with a brilliant name, which I've forgotten, Becky. So if you get a chance, remind us of that later. She investigates civil justice essentially from every angle, and you'll hear a bit more from her in 2 seconds, because I think we're about to now play the film.
So good morning, good afternoon, good evening, everybody. Roger and I are delighted to be with you here at this year's ILAG. We're going to talk about technology and access to justice. We're going to come at this from slightly different directions, and we have some different observations to make, but also some shared conclusions. But we're also going to leave you with a lot of questions, and we look forward to talking about those with you at the end of our presentation.
We've got to this from a slightly different perspective. I have been writing a blog for the last 5 years where my job has been to identify new developments, write them up, and send them out in the world for inspiration. So I've approached this very much from the bottom up.
So I'm coming at this from the perspective of a researcher. This is part of a project funded by the Open Society Foundations looking at legally empowering technologies. And so this is very much coming out of the second part of that. The first part of it was a landscape survey of things that consumers could use in the United States. And what I'm going to talk about today is informed by that, but also by looking at 3 or 4 of those technologies pretty closely to see how they can scale and how sustainable they are. One of the things that you see when you look at this landscape is that it's filled with an enormous amount of hope and optimism and spirit, I guess. But there are a lot of questions that remain about how this activity is going to play out. So you can create these tools, whether they're back office tools or consumer facing tools, and then they exist. But how can you get people to actually use them, and who's able to use them? How are you going to pay for this? Are consumers going to pay for it? Are governments going to pay for it? Is philanthropy going to pay for it? Lots and lots of these projects start as pilot projects, and they're led by charismatic, creative people who are disrupting or inspired to disrupt a space. But many of them stay at that scale, at a very small scale, forever. And so how can we grow this activity so it actually has the impacts that we're hoping for? And I think another question that Roger and I both have spent a lot of time wondering about is all of this automation just going to automate the status quo? Or is it actually going to change the game so that access changes and justice is more widely distributed?
So we agree on 3 basic points. The first is that tech's impact is going to be profound and uneven. Okay, well, that everybody will agree with that. The second is post-COVID will be worse, not better. We are not looking at a good time in terms of austerity, finance, poverty. Things will get worse for society as a whole and for those that we're concerned about in the world of access to justice. And nothing is inevitable. It's all up to play for. We may be successful. Technology may be successful, but it may ultimately fail, and the world may be worse in 2030 than it was in 2020 in terms of access to justice. That's entirely possible.
So as Roger and I have been thinking about and working on this, we've arrived at some factors that we think are going to be really critical in determining how technology impacts access to justice, whether things get worse or whether they in fact get better. And those are different aspects of jurisdictional and social and economic context. When all this started, we all thought that lawyers are going to be replaced by robots, but it turns out that human beings are here to stay, and their relationships are a critical part of the impact that these technologies will have. And then jurisdictions and CSOs and all of us face a really critical choice. And depending on how we make that choice, we're going to end up automating exactly what we have now, or we might be transforming it. And it could be better, or as Roger points out, it could end up being worse.
And in that decision, which way it goes, the context is going to be absolutely important. And we need just to pull the camera back a little before we look at technology to look at a range of factors and players that will be important in how technology works its way out. And these will include governments, which have power, funding, and influence, which can be malign or it can be beneficial, and that will change from jurisdiction to jurisdiction. The interesting thing there in a way is influence. Governments will be very reluctant to spend money at the current time, but they have a lot of influence. And you can see, as an outsider looking at the US, you can see the Biden administration looking as if it's going to upgrade its attention to access to justice. We can see our government, which has not particularly been using the language of access to justice, but it has funded various things like the Nestor Technological Challenge to Access to Justice. There are some things that governments do, and their attitude will be important. In jurisdictions other than mine, the attitude of government to regulation may be important. Legal aid authorities. We've abolished ours, but many jurisdictions have rather wisely kept theirs, and they have the same balance, power, funding, and influence, which will affect developments. Then we have the users, the core base of it all. They're really interesting because their expectations are probably changing. They've been locked up for a couple of years in many jurisdictions, and they've been using the net. So they're much more at ease with that than they have been. The barriers are well known and digital exclusion well explored. But what will they want and what will they be able to use as we move forward? And the fourth is providers. Now, I would draw a distinction between internal and external digitalization. I wouldn't make that too strong, but I think COVID has emphasized the need for organizations to operate remotely. Everybody's had to do it. And so everybody's got video communications, can handle remote contact with clients and users. Doesn't necessarily affect their external services, but interestingly, it might just be beginning to. You get bodies like People's Law School in British Columbia beginning to set up community education sessions where they're getting more people to a virtual discussion of rent arrears than they got to physical meetings. So that internal organization is blending to the external. And the next real barrier is to jump to how we can get the scale and the bang for your buck that's possible through technology in actually delivering services rather than in how they are being delivered. And scaling up and leadership I'll leave for later.
So in looking across different jurisdictions, which Roger's paper I think really brilliantly analyzes, and looking within jurisdictions, I think I would highlight three things that are going to really be powerfully shaping of this activity as it goes forward. One is thinking about how you're going to pay for it. So if you look at the way these activities happen in the United States, they're led by, as I said earlier, creative, charismatic people who are able to get different kinds of, sometimes government, but usually private philanthropic funding to start these things up. But if you're really going to scale them, someone has to invest in this over the long term. And in jurisdictions where governments are not interested in investing in social welfare or in legal aid in particular, where is that going to come from? And the sort of the hope and the kind of not very forward-looking perspective of the development of many of these activities is related to, I think, a general kind of myth we have about technology and how it's going to shape access to justice, which is that something magical will just happen. To go back to a point that Roger and Alan Patterson made several years ago, you know, we're going to magically somehow have much, much more access, and it's going to be so much cheaper. But we haven't really pulled that off yet. We haven't figured out how to make that shift happen. The second thing that's going to be really important in the rollout of these technologies, whether they are consumer facing or sited inside providers, is the degree to which jurisdictions are centralized or decentralized. So if you think about a place where there's really one jurisdiction, it makes central decisions, it has central funding. In that context, there's much more power, in essence, to go back to a point Roger made in the previous slide, to make the change happen. But if you're thinking about a context like the United States, the administration of civil justice is at the level of counties. There are over 3,000 counties in this country. And the central authority can say you have to do this, but it has to be implemented on the ground in over 3,000 different entities, and it's not even that easy. Each of those entities is filled with courtrooms that are run by judicial staff who are very conscious of their right to do their work the way they like to do it. And they don't take to change and innovation just for fun. So you've got maybe, I don't know, 30,000 jurisdictions, if you think about it that way, in a decentralized place like the United States. So you can have a brilliant idea, you can say we must implement it, but actually getting it implemented becomes very challenging the more diffuse an environment gets. And then finally, what these tools can do, particularly the consumer-facing tools, is really powerfully shaped by the way legal services are regulated. So you have that sets the bounds of the possible. So you have tools, probably some of the best tools help you make a form, right? Fill out the petition for a divorce or respond to a landlord's claim for unpaid rent. You can make a really good tool in a jurisdiction where legal advice is controlled by lawyers that can do that thing, but it can't tell you which form you ought to be filling out, for example, which is a really crucial piece of information that someone needs in order to understand how to frame their life problem as a legal problem. So these differences across contexts are going to very powerfully shape whether these technologies can survive, whether they actually get implemented and how, and whether they can do things that are useful or things that are really just window dressing around the edges of people's problems. Another factor that's going to be very powerful in shaping this is human beings. The relationships between human beings on a small scale and the way those relationships are organized on a larger scale. And I just want to illustrate some points that I learned while studying these consumer-facing technologies. One is that when technologies are new, when a product, let's call it that, is new, people are not going to magically decide that they want this thing or know where it is or that it's useful to them. People, for example, don't usually think of their legal problems as legal. So when these things start, they start by being distributed through trusted community intermediaries. So Citizenship Works is a program that helps you fill out the federal paperwork in the US context to regularize your immigration status. At this point, it's been around for several years and it has individual users. So people who find it in the wild and use it to do their immigration paperwork. But it started out being rolled out through immigration rights groups and community groups. And that's how many of these things will start so that people can actually discover them and connect to them. Another thing you see in this space is that community-led design, participatory design produce some of the very best tools because people are really important experts about their own problems. There's a fantastic program in New York City called Just Fix that started out helping people write really good complaint letters with evidence to their landlords about conditions violations. And the way these folks decided to work on that problem was by going to communities and asking them what their problems were that they needed help with, and what would enable them to better resolve those issues. So people are the ones who know. The best tools are tools that are driven by people and their needs rather than providers and their understanding. And then finally, I think there's a temptation sometimes to create a very cool tool and then think that it will build the human infrastructure around it, but that hardly ever happens. Tools leverage relationships that already exist. So in the United States, and I think it's spreading a little bit, there's a tool called the Legal Risk Detector, which enables a social worker or community health nurse to do a short assessment on financial and other abuse of the elderly, to create a risk score and ship that off to a lawyer who can then contact that person and say, maybe, you know, you have some issues going on and let's see what we can do. That tool automates relationships that were already happening. It makes them faster and more efficient and more consistent, but its rollout has been entirely by dropping the tool into programs where lawyers and social workers or lawyers and community health nurses were already in partnership. The relationships pre-existed the tool. And that's going to be true for many of these things that require collaboration across different professions. Tools won't make that they won't make that happen. They can make it smoother.
One way of looking at where we are now is that we're exploring the area beyond the static. Initially, the web was a source of information just like a book, but we're exploring what used to be thought of as the web 2.0, the interactive web. We're probably up to iteration 89 or whatever of the web now. But it can interact with us, and that's what we're exploring in the use of technology, which is really exciting. So we're getting guided pathways like MyLawBC. We can still look at the RecVisor, which is a giant, although built, 7 years ago now, in terms of showing what can be done, in terms of taking people through a process. We're talking ways of automating or semi-automating intake and assisting problem identification. It's that interactivity which is the key and the exciting thing to use. And further, but that interactivity has limits. You can, in some circumstances, and Joshua Browder is a past master at this, use it to automate the whole process of advice. But it has to be a very simple problem with a very simple law, with a very simple solution. It has to be the answer is 20 quid, that's it. If we're talking about, in a sense, real problems or problems of any depth, then the task isn't to automate it. The task is much more complicated. It's to see how we can maximize the person's capacity to deal with it themselves, legal empowerment, and then provide the best mix of individualized and digitalized assistance which will help them. And in that process, AI, and I think the language has changed about this recently over the last 2 or 3 years, AI is a tool, it's not the answer. In the end, it may be able to help us much more than now, but for the moment, it will help us in stages of the process. And what's coming out of this process of interactivity are new forms of blended services, which are taking the now old notion of unbundling, where the user did most of what they could and let the lawyer do the rest, by making it more complex by integrating and integrating automated elements into that, extending what the user can do themselves by self-completing documents and so on, and mixing that up with video and other guidance and individual consultation over the net. So you get a product which has really impressed me, Hello Divorce, which is a product coming out of the private sector in a couple of states in the US, which mixes these things all together. And case management software like Clio has the potential to lie behind that sort of integration and to manage. Clio is just an example. It's not an advert. And even more interestingly than just one service blending different elements is that different services can be blended together. So if we take Just Fix, it's a blend, and you end up going through a process helped by the net, and then you're directed to a tenants organization to help you. Flows is an organization set up to help women survivors of abuse, which is a combination of private practitioner lawyers and information which is on the web and videos and so on, assisted court documents. So it's a blend of different services in a new form.
So all these developments are very exciting and they're very interesting, and they have changed the game a little bit at least, but I think Roger and I agree, there's a bigger question here. So we know that the justice systems in most of the countries that we're familiar with are slow and expensive and inefficient and biased, and that ordinary people face significant power imbalances when they come into these contexts. We could just automate all of that. It's very easy to automate bias. We see many examples of that, for example. So will we just automate the mistakes that we're making now? Will we actually do something to correct some of them? Or will none of this very much matter at all? Will all of this activity just be ignored?
So these are the questions that I would ask about the future. And on the future, I'm a conditional pessimist. I answer all these questions pessimistically, but I add a but. So is the use of technology doomed to be fragmentary? Frankly, yes. But you can see little glimmers of light. You can see LawWorks, a pro bono operation in the UK, using software developed in Australia by Justice Connect. You can see little links across. New York just has a new website in housing. It's just itching to be compared with other housing websites of a similar type around the world, and people learning the lessons. Can we work to a shared methodology on evaluation? No chance. But could we do much more, frankly, to evaluate projects? And could funders do much more? Very simply, to say to somebody applying for funding, 1, well, what are your goals? 2, tell us whether you hit them, and if not, why not? And then 3, publish the results. Very, very simple changes could very much help the dissemination of experience. Are national leadership strong enough? No, they're not. And then particularly, this takes us back to the wider context. You take the UK, we have the access to justice landscape would have an initial advice operation, citizens advice, law centres, a not-for-profit sector, private practitioners funded by legal aid, private practitioners, 1 or 2, trying to get through on funding themselves from user fees. It's a mess. It's a mess apart from technology. And there is no leadership strong enough to hold that together. But it might be that governments could see that it's such a mess that they want to do something about it and use their influence too. The court and tribunal digitalization issue is enormous, but it's going to affect our people. If they go to court, they're going to have to operate digitally. Will that be another barrier, or will it be an assistance? That's an enormous issue, which I'm sure we'll discuss at some stage during the conference. Technology is international and jurisdictions are national, and that is a fundamental tension because everybody's getting this experience. You can go to Australia, there are wonderful things happening. New Zealand has some nice things going on in AI. States is a wonderful cornucopia of experiment. There's even things happening in the UK. But how do we jump the border? How do we find out? That is really hard. I commend ILAG for its existence and for this kind of session, because it's one of the processes by which voluntarily we may be moving to more coordination. And the final issue is technology is going to be needed because the money isn't there to provide legal services in the form that we in the UK, to take an example, have expected. We ain't going to get the money for the old legal aid scheme, which for us has been basically abandoned or certainly rolled back seriously since 2012. So we are going to have to rebuild a new system, and it's going to have to be rebuilt on a new philosophy, and it's going to have to incorporate people doing the maximum they can for themselves, legal empowerment, which provides a link for us with the world of in India, the organizations operating in places like India, Bangladesh, and so on, which have much less resources and always have had. And we're going to have to incorporate a notion of legal empowerment within our new conceptualization of what services are provided. And will that be an easy process? The answer is clearly no.
So as a researcher, when I look forward, certainly there are many questions that practitioners have, that scholars have, that other kinds of observers have, but it's not like we know nothing. We actually have if you think about the public experience of justice problems between the work of Pasco Pleasance and the OECD, all of the national legal needs surveys that are going on, Hill, the World Justice Project, there are lots of things we know about ordinary people's experience of justice problems, but we're not really making effective use of those. So I'll give you some examples. Everywhere you look in the world, where we've ever bothered to ask, most of the justice problems that ordinary people experience do not make it to lawyers or to courts. But if you look at where most of this activity is happening and where most of it is generated, it's in lawyers and courts. And so all of this energy, which could do some valuable things, is at the very top of a gigantic pyramid of activity that, by the way, is at the end stage of its horrible development. Prevention would be much sooner, for example. So shifting our attention away from the places we're already working to the places where nobody's doing any work would be a really important move here. And we know that, but we're not doing it. Another thing that I think we know, but are not doing, is that allowing people to give input into what their problems are and how they think about them is a critical way of designing solutions that actually meet their needs and capacities. Community-led design is an example of this. And I think everyone who goes to these conferences and works in this space knows that that's a really important tool, but it's not very widely adopted. In part because it requires you to shift away from I'm a provider who has a thing and how can I get it to more people, to what is it that people actually need and what ought I to be trying to bring to them. It's also expensive because you have to go out and talk to people and do research before you design the thing. I think another thing that's going to turn out to be predictable, but also disappointing to many people, is that the shift that Roger's describing, where the UK is pulling back from legal aid, is part of a general trend in the Western democracies that used to have welfare states of different kinds to move towards responsibilization, if you want to use the European term, or what we would say in the United States, consumer freedom and choice, right? We're gonna allow more different kinds of providers to sell this stuff on markets. And there are ways in which that could play out quite well. Things could get cheap enough that people who are currently excluded from justice could be able to buy a product that lets them get some kind of resolution to their justice problems. But when you rely on markets to distribute things that we think everyone should have, like food or a place to live or justice, it has predictable effects, and those predictable effects are on both sides. So if we open up provision of legal services to non-lawyers in the United States, which we're moving to do, who will move into that space? People who can make money from doing whatever it is that they think that they're doing. People who serve clients who have money to pay. So that's one, that's the supply side. And then on the demand side, if the way you're going to distribute something is by making people pay for it on a market, then people who have more money to pay for things on markets will get more of the thing than people who don't. So this might open up, it may well open up access, but it's going to shift an inequality rather than eradicating an inequality, and that's predictable.
So that's our two voices on technology and access to justice. And how will it all add up? Well, you probably have as good an idea as we do, and we look forward to hearing from you in terms of points you want to raise, questions you want to ask for the rest of the session. Thank you.
Thank you very much, Roger and Becky. That was terrific. There's an absolute mass of things to think about there. I've had the first question from Yazika. I hope I pronounced that correctly. The risk of fragmentation is that people may not know which platforms to trust or which to use, or there's competition if there's one for every issue. But how do you make a non-fragmented one that isn't too big and cumbersome? Where's the sweet spot? So how do you cope with that kind of plethora of different solutions which consumers just don't know how to navigate? Have you got any thoughts on that, Roger or Becky?
Well, I think that's a really good question. I'd slightly dodge it. I'd say that at the moment, we're at a phase where, as a policy in a way, if I was in charge of legal aid in New South Wales or anywhere else, or government, I would say let 1,000 flowers bloom. Let's see what's out there. Let's till the earth and see what comes up. And we'll deal with the coordination problem afterwards. The end issue will be to coordinate and to bring these things together. And that's where I would see there's a role for legal aid authorities, there's a role for government in terms of building up, and this will be really hard to do, building up some coherence in a series of fragmentary provision. And that won't necessarily take much money, but it will take considerable knowledge, considerable engagement, and considerable drive to do effectively.
Are we able to unmute Becky? She is.
I've been released. I think Roger makes great points. I think there are, in different contexts, you might achieve that goal in different ways. So if you're letting 1,000 flowers bloom in a place where these are market reforms, you can hope for some kind of voluntary quality mark scheme where consumers can come to trust a third-party brand that says, whatever this is, it's legitimate. I think that might be a possible way that you'll see this develop in some contexts. Certainly in my context, the government is not going to step in, except in experiments in different states, and regulate some of this activity. So in the United States, we have I wish it were a movement, but it's about 3 states that are exploring something called a regulatory sandbox. The idea is that if you're going to do something that violates the current rules about the practice of law, say with a fancy computer program or with a fancy computer program and people who aren't lawyers doing traditional lawyer stuff, you apply, you move into this space, and then you're monitored to make sure that your consumer harm is at an acceptable level. So you might have experiments like that, but in a big diffuse place like the US, you would never do that nationally. It would only be state by state.
Yeah, I wonder about the regulatory question quite a lot, because of course in England and Wales, we don't have the same level of regulatory inhibition, and we don't have the same fragmentation either. And yet I don't feel like, Roger might have a view on this, I don't feel like we're further ahead than the States. In some ways, we might think we're a bit further behind. So do you both really think regulation is the key problem, or is it just simply one of the boxes that needs ticking off on the way?
Well, I think that's an interesting question, because I think it points to the difference of perspective between me and Becky, and it's a difference between someone who's in the UK and someone who's the US, where I think regulation is much more of an issue. But I want to take up the fragmentation point. You can't get away with saying we don't have a fragmentation problem in the UK, because there's a very basic one. If you take someone through the process of identifying a problem to resolution of that problem, in the UK context, we've always had a fragmentation between a citizens advice service and other agencies which have dominated the initial identification of problem and been seen totally, to use a Scottish phrase, out with the legal aid scheme, completely different, funded by a different department of government, never talked about in the same context as legal aid, and then we've seen legal aid. Now we've got the collapse of legal aid. We've got funding going into the Citizen Advice Service. We have a totally incoherent legal aid scheme, a legal aid provision at the moment, irrespective of technology. Chuck technology into that, and you've got a series of projects bumbling around. You've got MenCat just got a grant out of the Nesta scheme for a chatbot to help in mental health cases. You have fragmentation in the UK that will rival that, which you can see in other jurisdictions. I think you can see in every jurisdiction.
Okay.
That always makes me feel so positive about the future.
It's been doing it for decades.
I think in the US context, lawyers' monopoly on the practice of law is much more extensive than in most places in the world. I mean, most places in the world, lawyers control rights of appearance, and here they control everything. But I think certainly in jurisdictions like mine, whether a new thing can be useful at all is powerfully shaped by these regulations. Like, it can't do anything that's not just give you information or guide you through a form. But if we're thinking about, it's not just in the United States where you have lots of people appearing in courts with no kinds of assistance. That's happening all around the world too. And finding people who are not traditional providers to offer that assistance is about the regulation of who has rights of appearance. I would love to know why McKinsey friends have not spread further in the UK, because they are allowed, right? Because there was a court case that permits people who are not lawyers to accompany litigants in court and give them advice on the fly. I mean, I think there are definitely forces other than regulation that keep change from happening, but it's clearly a key, at least in my jurisdiction and several others, a key break on the usefulness and expansion of this stuff.
Yeah, I guess my take on it would be the regulatory thing is a necessary but not sufficient condition for change. The McKenzie Friends thing might be about trust, and maybe lawyers have more trust than McKenzie Friends, and that's the kind of double bind we're in. I don't know. Let me take another question though. It came from ME, so that sounds like an initial. So sorry, ME, I don't have your full name. It says, recognizing how legal issues intersect with other problems such as health issues, do you see technologies that recognize non-legal pathways as in the digital space as being as or more important, I suppose? And I was interested in this and linking it to your point about users and leveraging the knowledge of the people with the problems, Becky. Do we have the right kind of stakeholders around the table when we're thinking about these issues? Are we not dominated by lawyers and legal academics and legal aid policymakers? Do we need different people around the table?
I think we absolutely need different people around the table. What you see in the US is these sort of, there's an expression from the tech world, unicorns. They're extraordinarily creative, charismatic, and also lucky people who show up at the right place in the right time and do something extraordinary. Just Fix is a great example of that. They're made possible by their community-led design model, but also the incredible open data laws in the city that they're in, and the fact that their city is invested in trying to preserve low-income private housing by pouring millions of dollars into the housing market in the form of rent subsidies. That doesn't happen everywhere. But things like that can happen in many different sorts of places if all of those players who usually are not talking to each other could come together.
Okay, thanks. Avram, you sound like you've got a question. Would you like to, can we unmute Avram and get him in? Matilda, I don't know if you want to be ready to ask your point as well. Are we able to unmute Avram?
Mine was a small point, Richard. It was really just about, it was answering this, aiming to answer this question of fragmentation. And I just wondered whether they both or either thought that Rechtwijzer might not be the right example. That is a beginning from a state or legal aid system, which then was opened up to more of the market. That would give a little bit more certainty and trust to those who began to use it, and then could be adapted by others for in different ways and for different approaches. That was sorry, that was the point.
Thank you. Are we able to unmute Nimrod? And Nimrod,
Good morning, everyone, from sunny London. Let me just scroll up to my
Ben,
question
sorry,
again.
I thought Nimrod was strange.
It's actually Nimrod.
Are you able to ask your question, Ben?
Nimrod,
yes,
not
Richard.
strange.
What role do you see for technology in reducing inequality of arms between parties? For example, between a landlord and a tenant, in the context of a widening shift, as we have in England, from judicial adjudication to ADR?
Becky,
Well, these are two questions that raise major issues. I mean, number one, the fate of we've got Peter on the line somewhere. The fate of the Rechtwijzer, I think, would make a good 2-hour session in itself. Let's say it failed, which is perhaps a contentious statement, because it still continues, in fact. Why? And if it does, what does it prove? I see the Rechtwijzer as a complete beacon. I think we will, you can still see it as ahead of the field. Before people started going on about legal design, it's a brilliant example of legal design, and a brilliant example of how you could help people through a process. And I think that the Rechtwijzer will ride back into town, and we'll see it or some development from that later in the future. I think that leads on to a second point, which is about the role of the private sector. I think it's a really interesting issue about the role of the private sector. The question for technology in the private sector is, can it bring the unit cost down so that people of small means, but some, can have access to assistance, which is provided at a lower unit cost because of technology. And there are some explorations around that. Hello Divorce, I really commend to people. It is an attempt to do that relation divorce, operating in 2 states in the US. I think that's a really interesting example. Behind us stands the wreckage of a load of those firms. Well, I think it stands, I'm interested in Becky on this, the wreckage stands behind us of things like co-op legal services that thought that assisted DIY was going to be the way of making a fortune on a myriad of small punters. Well, it didn't work. I mean, interesting why, and will that come back again? And will technology open up unbundling to a much more sophisticated presentation where it's not just you give people information and they do it themselves, but you can take people through a process, which involves doing forms, but actually involves helping them manage the process. And then there's finally the point that Nimrod raises, which is complex, because if you're in a police station being interrogated, I don't want a laptop. I want a lawyer. I'm being thrown out of a flat by my landlord who says, stuff the COVID regulations, you're out in the street, sunshine, your rent 6 months out of you. You know, it's no good pointing to my phone and saying, well, you know, the app says no. The app says no, don't mean nothing in a real life, doesn't mean much in a real life situation. So that's why we will need lawyers and representatives who play a role simply in a way by their presence. On the other hand, what technology can do is it can put into your hands as the user information which otherwise you wouldn't have. So let's wrap this up by going to the RecVisor. The RecVisor began to say, well, look, you're in this situation and the sort of deal you would expect out of a court is this, for access, for alimony maintenance and so on. And so technology can provide you with that sort of information, which hitherto has really been the province of lawyers. So there is a democratization factor there, and we can maximize that. But in some situations, stuff the phone, stuff the iPad, stuff the laptop. I want a lawyer. And for all the barking at lawyers, actually, frankly, they have a value.
It's interesting you say that, Roger. I was talking to somebody who I would regard as a really quite thoughtful criminal defense person, and he told me that actually advice in the police station, other than for clients with mental health problems, which is quite a large number of them, of course, it's really quite effective and efficient. And this is a person who cares about effectiveness as well as efficiency. So just as a counterpoint to that, I'm being encouraged to maybe try and bring in Gabrielle to talk a little bit about RecVisor. I guess the question, everybody's very positive about RecVisor because it looks great and it makes sense in theory, but it couldn't get the clients. And I know part of the problem was maybe advertising and support from the authorities around that, but I wondered if there might be something more fundamental going on. But Gabrielle, perhaps you could share a couple of thoughts on RecVisor.
Sure. What I can talk about is Amica, which is a product that we've developed in Australia, from learnings from RecVisor. I'm just going to try and turn that down a little bit. Okay, I think is that much better? And can you hear?
Yeah, it's great.
Yeah. And so many of the issues that have been discussed today, we have experienced in the development of Amica, and further into the program, I'll talk a lot more about Amica. But what we have learned is very much what you say, is that through technology, we can empower clients to with information, and then for a certain category of client and problem, they can be, we can assist them through online dispute resolution to get a result, and through the Amica product, a result that's able to be filed and accepted at court. What we realised right from the beginning, and something we're still working on, and very much reflect what has been said today, if you have the best party in town, it's no good unless you've got any guests. And so it's all about getting users, getting the word out to users and getting those sort of mass use. And of course, the AI that we've developed to assist us in relation to property, that benefits from volume of use as well.
Thank you. Thank you very much. I'd like to try and bring in Julie Bishop now. Julie, if you're able to ask one or two of your questions.
Okay, thank you. Look, thanks, Becky and Roger. This is such an important discussion because it's really at the heart of what's happening with access to justice at the moment. And that is, there has been much debate, and I've heard a lot of it at ILAG over 15 years, about the role of technology. But we really need to shift this debate from where it sits now on digital exclusion, whether someone can hit the return key or not, to this question of what impact is this having on our principles of equal justice and respect for the rule of the law. And really the question is, how will defendants, along the lines of what Nimrod's saying, feel they've been treated at the end of a digital resolution process where they feel unfairly treated? What are they going to do? Will people turn away from using the state to resolve their solutions? What does this mean? But equally importantly, how do these processes apply equally to all? In my question, I mentioned Boris Johnson, who had a much publicised small claim debt. I wonder, did he have to use the online small claim system that other UK citizens must use, or did he go outside that solution? These are really important questions for equal justice and the rule of law, particularly in populist times.
Any quick responses from that, Roger and Becky? And otherwise we need to move on to the next session.
Well, there's just the obvious one. I mean, you know, everybody goes on about legal empowerment and self-empowerment, DIY, and the example I always use is, well, you know, if Murdoch has a legal problem, does he sit down and work it out for a couple of years, a couple of hours? Johnson will be the same. Or does he grab a lawyer and say, you fix it for me? Well, they get a lawyer. So people who can pay and can choose get lawyers. Lawyers would be better. But look at it from the other part of the lens. We never had an adequate legal aid scheme, and we will never have one again. It's in tatters. People are getting nothing. So we have to, our job is A, to provide some form of adequate cover, and B, at the crunch points, if you're talking about a case going through a court and so on, there being the moment like there is there has to be the option to cross over to a physical analog position, a right of appeal, a right of review. But that doesn't mean that we can't use technology in courts and tribunals up to a point, and it doesn't mean we shouldn't use it to provide people with assistance and information, which otherwise they wouldn't get.
Thank you. Becky, did you want to say anything?
Roger said it perfectly.
Thank you. Everything's in tatters, Roger says. We maybe have 1 minute just for one more thing, a point about rectifiers. I understand, Peter, you'd like to say something. And then we'll need to move on to the next session.
Okay, great, Roger. It's nice that rectifier is at the table, but let me try to get some feedback on the process of rectifier and more generally in the use of IT. In fact, we all know how important the development is of technology for sure in the future. I think it's the only way forward, and lessons learned are it's a long-lasting process. If you look at what happened with rectifier, is it fell in fact with the support of our government, the Dutch government. So you have to make a decision. It's something to do that clients need to rely on it. So you need to provide it with a quality mark. There are a lot of IT programs, but how do customers know that it is a reliable and system you can use in your own interest? That's on one side. So you need this type of quality marks. You need to be aware that you're always talking about complex system. You mentioned who do we need at the table? I think you need at the table at least the customers themselves, so that you can develop a program based on the client's wishes and how they can deal with the problems they face. And most importantly, it's an issue. I assume in every country, it has something to do with vested interests. So in our country, private lawyers don't like it. the use of IT when it has come to in competition with their own work. And here are in the issue of what's said by Roger, how can you jump the border? And it's not only international, how you can cooperate with our jurisdictions. We try to do our best in that way, but everyone is also looking to his own interest. So it's, I think, quite complex, but at least had to start with the customers itself. And Roger, and not completely agree with him, post-COVID is that a period that will say, okay, there will be a lot of problems for IT projects. And I think maybe the most important lesson learned from COVID, if you see how quickly jurisdictions, courts develop in a way that they need to use IT products, I think it's a really way forward. How can you concentrate, stimulate people just to get rid of people who don't like this kind of developments? It is centralized, you need support, you need the quality mark, and you need the customers at the table. Okay, thanks.
Thank you, Peter. Thank you ever so much. Thank you, Becky and Roger. We may be able to bring you back in at the end of the session. We'll see how things go. Colin, I've seen your question. If we could just park that for now and maybe come back to it, because it is a really interesting one. I'd like to move on to our next two talks now. I'll introduce them one after the other. So first we'll hear from, is it Angelica, have I pronounced that correctly?
Angelica.
Angelica, my apologies. So Angelica is a lecturer and researcher at Mykolas Romeris University in Lithuania. She's a mediator and a lawyer, and between 2005 and 2018, if I've understood correctly, she was the director of the regional and national state guaranteed legal aid services and a member of the state guaranteed Legal Aid Coordination Council. So Angelica, we'll play your video now, and then I'll introduce Gabrielle and hear hers, and then we'll have questions to you both from the delegates.
Welcome, ladies and gentlemen. Today, I am going to present digital exclusion, the influence of lockdown to the legal aid provision in Lithuania. On December 31st, 2019, the World Health Organization started reporting cases of a new type of illness that later on shocked the whole foundation of humanity. As more and more people were getting sick and dying, there was a clear understanding that the world was not prepared for the outbreak. Countries and cities across the world had to be locked down in order to slow down the pandemic. The virus affected every single person. Following the COVID-19 pandemic, the strict quarantine was held in Lithuania. All state institutions were closed for several months, including the legal aid facilities. Most of the services on legal aid and court proceedings were performed remotely. Movements among municipalities and contacts of people were restricted. Based on that, a survey was carried out in order to identify what is the impact of quarantine restrictions to the provided legal aid. Lawyers and prisoners were asked to comment on legal aid experience during the last 13-month period. 15% of legal aid providers participated in the survey. They provide legal aid in all types of cases. The most common communication between lawyers and the clients are through emails and phone calls. Surprisingly, online video communication platforms were rarely used. Direct contacts make a considerable part of consultations. Due to the restrictions, law firms were closed. Therefore, lawyers had to adapt. Some lawyers provided consultation in the street or at the park. Others had the conversations next to the prison fences. Ordinary online video communication platforms were used for online communication. The most common one was the Zoom communication program. The survey revealed that less miscommunication occurs when phone calls and emails are used together with online video platforms. Despite the restrictions, the legal aid in most cases have been provided on time. However, the legal aid beneficiaries and lawyers pointed out that in many cases it was difficult to understand each other. Regarding video online communications, the legal aid beneficiaries revealed various problems. The confidentiality of communication with the lawyer was not always ensured. Conversation could be heard by outsiders, or onsiders can be seen through the screen. Legal aid beneficiaries also had some psychological difficulties in communicating online. They could not concentrate themselves, felt uncomfortable during the conversation, felt stress during the conversation. Despite existing difficulties, the legal aid beneficiaries rated the quality of legal aid as quite suitable. The quality of services of private lawyers are quite similar to the quality of services of legal aid providers appointed by the state. The following statistics shows how the court hearings were organized during the lockdown. In civil and administrative cases, most commonly lawyers connected to the court hearing via online video platform without participation of the client. Whereas in criminal cases, the court hearings were organized in courtroom with actual participation of the parties. The problems indicated by the lawyers could be divided into several groups. The technical problems, organizational problems, restrictions in access to case files, confidentiality not always guaranteed, insufficient capacity of the parties to the proceeding also identified. Speaking about technical problems, it should be mentioned that Zoom online system was implemented in all courts. Some courts are not suitable for remote hearings. The participants in the process are not visible enough. There are computer problems, poor internet connections, frequently internet disconnects, poor sound and image quality. Often speeches of the participants were not heard. And defendants in some prisons do not have access to the Zoom program. facilities are not properly equipped. Talking about organizational problems, it should be mentioned that participants in the hearings are sometimes encouraged to hurry at the time for hearing. Online session is expired. The lawyers are not admitted to the court premises before hearing. They have to wait at the door near courthouse for 20 minutes. In prison, the lawyers has to wait a long time for client to come. Prisons often do not allow meetings because of the quarantine. The premises do not meet the health security requirements. Due to the increased risk of coronavirus infections, lawyers sometimes refuse to provide legal aid. There are also restrictions on access to case files. The information and materials needed for preparation of defense was not always available on time. There are pre-registration requirements to receive legal aid files. In court hearings on suppression, not always the lawyer has access to case files. Remote hearings connect detention center and the court, and the lawyers in detention center and prosecutor submit the case material to the court directly, and the lawyer do not have possibility to have case review. Talking about confidentiality, there are in some cases no direct contact with the lawyer. Before and during the court hearings, the lawyer cannot discuss the cause and position of the case with the client without outsiders. In remote online hearings, there is a problem with removing witnesses from the court hearing. Witnesses hear the whole process while waiting for an invitation to speak. In addition to that, there are also insufficient capacities of the parties in the proceeding. Not all of them were able to connect with audio and video to Zoom. Inexperience of participants also on how to communicate in the process. Due to the mentioned problems, there was poor quality of court proceedings. Court hearings were adjourned for up to half a year. Process with many participants were postponed until the end of quarantine. And parties in the proceeding have refused to attend the remote hearings. The number of cases has decreased significantly. What are the lessons to be learned for preparation of the new lockdowns, we should ensure confidentiality, improve the hardware and software, develop operating procedures, prepare guidelines for easy access to online platforms, establish network of premises, equip premises for remote communication with a lawyer. And thank you for your attention.
Thank you very much, Angelica. We're going to now hear from Gabrielle Canny. Gabrielle is currently the director of and CEO of South Australia's legal aid agency, which is the largest and busiest legal practice in that state. And she is one of the directors of National Legal Aid, the body representing Australia's legal aid commissions. So we'll hear now from Gabrielle's video, and then we'll have Gabrielle and Angelica and possibly Roger and Becky in case they would like to chip in too, but we'll have questions for Gabrielle and Angelica after this session. So please put them in the chat if you have them. I can see one or two of you have done already, so thank you for that. So if we could play Gabrielle's video, please, that'd be terrific.
Wherever you are in the world, I send you my warmest greetings from down under. My name is Gabrielle Canny, and I'm delighted to be joining you from Australia to speak about AI and family law and our national legal aid project called Amica. I begin by acknowledging that I am on the traditional lands of the Kaurna people in South Australia. I pay respect to their spiritual relationship with this land and to their elders, past, present and emerging. When love breaks down, technology and the law must unite to help people help themselves to put things right. That's daunting for legal systems steeped in decades and centuries of rigid approaches to handling family law disputes. However, doing nothing is not an option. Across the world, there is growing demand for online help that empowers people to resolve their disputes fairly, on their own, without lawyers, without lengthy legal processes, and without excessive cost. In response to that rising demand, growing numbers of online platforms are being developed, including the Amica service funded by the Australian Commonwealth Government. Amica is an online service that encourages separated couples to log on rather than lawyering up. It empowers them to reach amicable agreements themselves regarding their property and parenting arrangements. In a nutshell, here's how. Amica guides separated couples through a step-by-step dispute resolution process. That process helps them reach agreement and record those agreements in plain language on a secure digital platform. It also guides them to specialist legal and non-legal support services at times when they need additional help. This ensures they have access, if required, to professionals such as mediators, counsellors, other supports, including family violence services, and in particular family lawyers. In fact, throughout Amica, people are encouraged to seek legal help or further information, and are provided with links to free helplines and legal aid web chat services. Amica provides information about a wide variety of issues regarding separation. It uses conversational language and avoids legal jargon. And if they wish to, Amica helps users create legally enforceable agreements and applications to court for consent orders. Amica is not suitable for all couples and all situations, and it cannot replace that expert one-on-one assistance provided by lawyers and family courts. But it can empower many couples to better manage their separation and reduce the number of areas in which they disagree. Amica's dispute resolution process is best suited to separated couples who are reasonably amicable, are willing to negotiate and communicate online, and whose property and parenting arrangements are relatively straightforward. Amica delivers its help in two key ways. Firstly, a website that anyone can use to get free information about family law issues. And secondly, the digital tool within that site that enables separating couples to communicate and negotiate online about parenting and property matters. Artificial intelligence plays a key part in Amica by helping people to reach fair agreement about the division of their assets. The suggested property division is designed to guide the negotiation process, but it's not meant to replace legal advice. Users have the option to either agree to the suggested division or use it as a guide to formulate their own agreed percentage split. Once users agree to a suggested percentage division of assets, they can put proposals to one another regarding how that division of money and property will take place. That is, who gets what. Either party can nominate which assets they wish to keep, transfer or sell. Once users reach agreement about the division of their property, Amica can produce a written agreement that reflects that agreement reached. Amica's dispute resolution process also helps family work out parenting arrangements for children. This process focuses on the best interests of the child and, of course, does not involve artificial intelligence. But it does feature smart technology based around the needs of the user. For example, it has a very popular interactive calendar that helps parents to reach agreement and record their agreement about the care arrangements for their children. This feature enables users to easily select their preferred days and nights with their children. To help users arrive at a written agreement, Amica puts a series of questions to them regarding their circumstances, their children, and their assets. Users have the opportunity to provide additional information regarding their answers and can engage in an online dialogue with the other party about the details they're providing. This is designed to encourage full and frank disclosure regarding the assets and liabilities of the relationship. During the online discussion, users can also upload supporting documents to support what they've said. Amica is not a pie-in-the-sky project dreamed up by computer boffins and pointy-headed lawyers in ivory towers. Right from the start, we've been guided by ongoing feedback from everyday people with lived experience of everyday family law problems. They helped us design, build, and test Amica. They outlined what they wanted in an online service, and they helped us test and refine our prototypes. Their insights were invaluable to the success of the project. And as we improve the functionality of Amica, we continue to be guided by feedback from users. At the outset of this project, we commissioned independent research to find out, do Australians want this type of service? And if so, what features do they need it to have? 78% said they would use an online service of this sort, an extraordinarily high number. The remaining 22% were intrigued and could see that parts of the system could have assisted them with their family law problems. This research that guided Amica's design showed Australians want online family law assistance that provides three things in particular. Firstly, online tools that help them resolve disagreements without court action. Second, they wanted clear and comprehensive information that's free of legal jargon. And finally, they wanted easy access to support services, mediators, counsellors, lawyers, social workers, and domestic violence services. With funding from the Australian Government, Amica was created by National Legal Aid, the peak body of Australia's legal aid commissions. Legal aid family law experts across Australia provided key data and crucial input to assist Amica's development. For decades, legal aid agencies have dedicated themselves to helping people resolve family disputes fairly, efficiently, and cost-effectively. Amica is an extension of this work and complements their legal aid services and resources. Most importantly, the involvement of legal aid and our family law experts has resulted in a high level of trust by users of Amica. The Family Court of Australia and the Federal Circuit Court were also regularly consulted during Amica's creation. They have endorsed the tool and we are linking to it from their website. By reducing pressures on courts and legal aid services, Amica can help these bodies focus more closely on matters that cannot be solved online. In addition, the Commonwealth Attorney General's Department played a key part in funding and guiding Amica's development and is now actively promoting Amica to the Australian community. Family violence, unfortunately, is all too often a feature of family law disputes. We knew we needed to incorporate important features to protect vulnerable individuals who are dealing with issues relating to separation. Amica's dispute resolution feature is not appropriate for all couples, and it screens out people through a series of questions whose circumstances are not suitable for Amica. Amica also incorporates sentiment analysis, technology that detects inappropriate comments and stops them being communicated to a former partner. The technology informs the person making the remark that their language is not appropriate and will not be permitted. At many stages of its online dispute resolution process, Amica also provides warnings about coercion or pressure to settle on unfair terms. It also uses two-factor authentication to avoid impersonation or coercion by the user. There is no charge for the information Amica provides about separation and family law. Likewise, there is no charge for the settlement range figures that are suggested by the AI software. Very modest fees are charged for written agreements and applications for court consent orders. These fees range from 165 to 440 Australian dollars per couple. In US dollars, that's a range of $130 to $340, or in euros, 106 to 284 per couple. We can keep the fees very low because of our not-for-profit status. The fees fund ongoing maintenance of the Amica service and are waived for users who receive income support welfare payments. Currently, that's about 50% of our payers. Now for some stats. To date, more than 2,500 matters have been commenced on Amica. 600 asset division suggestions have been provided by its AI. More than 250 property agreements have been finalised. 200 consent order court application documents have been prepared. More than 200 parenting plans and parenting agreements have been finalised. And the Amica site has received more than 200,000 page views. These initial figures are very encouraging. But we know from the RecVisor experience, we must relentlessly try to inform people about this new approach to resolving family law disputes. The challenge for all legal aid service delivery is that all too often, people don't want to know about a new service until they find themselves in a situation where they need that service. So through social media and other traditional channels, we are striving to get the message out that there's a new way of reaching agreement when couples split. Worldwide, there is a growing number of family law online dispute resolution platforms. However, in Australia, Amica stands out from that field for two reasons in particular. Firstly, Amica allows users to complete the online dispute resolution end-to-end process without any compulsory involvement by a lawyer. And second, Amica is a not-for-profit service supported by legal aid the courts and the Commonwealth Government. And so in conclusion, AMICA responds to community demand for digital solutions in the family law sector. When it comes to family law, we must embrace solutions and combine the expertise of people from a range of disciplines. AMICA was created by consulting family lawyers, digital designers, and everyday people with lived experience of divorce. AMICA arose from that collaboration and consultation. AMICA is not a magic bullet that will solve all the challenges facing Australia's family law system and all the difficulties confronting separating couples, but it adds significantly to existing services and gives separating couples more options, more information, more guidance, and more ways to solve their problems. This is good for families, good for the community, and good for courts and the wider legal system. Thank you.
You both, they were terrific presentations, really interesting. So we've got several questions already, so I'm just going to start with those. Keep them coming though, please. So Mirha and Susie are both asked something similar, and it's a question for you, Angelica, which is when you talk about the barriers to the use of the technologies, are there any lessons being learned as changes being implemented for ongoing practice? And Mirha says something similar, which is, do you have a roadmap already in Lithuania as to how to continue with these challenges?
Thank you for the questions. And I would answer in such a way that the survey results which we got, the survey was finished in May and they are new. And now we are working on the roadmap, how to deal with those issues identified. However, some steps are already taken to improve the situations. We're now developing IT program bases, which will help lawyers to communicate with clients, share documents, and to follow up the progress of the case. The client could follow up the progress of the case. But this is not, this does not solve the problem communication with the court. And of course, courts hardware is improving on every time and now also. And however, the software is not suitable quite for the court hearings, because Zoom system is helps just when you the small number of participants is, and we need to think how to organize court hearings, to develop new software for such hearings, and we are now working on it, in progress now. And to help lawyers and judges, there are trainings already organized, and they are organized on time to time. Of course, for the clients, it's not so easy to organize the trainings because they don't want to be trained or to study how to work with IT systems. They see the problem when they need to communicate in the court hearing, and because of that, we think we need to develop simple and detailed guidelines how to communicate during the remote court hearing. So, and I think that maybe answered your questions.
Thank you. Yeah, great. So a question for Gabrielle now from Josika, is it? Josika?
Just to make it easy.
Say that again. So
Jessica. So just the an S instead of the Z makes it easier for everyone to pronounce. A bit like Angelica. Okay, thanks Gabrielle for your presentation. I'm just across the ditch, I suppose, not even the ditch, but in Victoria. And I just quickly had a look at the Amica website, and I was just curious about the suggested exclusion criteria or self-exclusion criteria, one of them being about not needing to split your superannuation. And, you know, given that we have the issue that so many women either have little or no superannuation and invariably much less superannuation than their husbands or soon-to-be ex-partners, it seems to me that this would then exclude a whole lot of people who could otherwise benefit from using a platform. Have you got any data about that and whether that's actually become an issue, or do you kind of suggest ways for people to, you know, get around that and work out those kinds of issues themselves as well? Because there's a you know, different set of laws that apply to superannuation splitting and how you go about that.
Yeah, thanks very much. Yes, in the design of Amica, we were very aware about the complexities of super splitting. This tool has been designed for the more simple property discussions or settlements. We are developing more functionality in relation to super splitting. And of course, the Australian government is also making progress towards assisting people settle their superannuation entitlements in a family law dispute. For the moment though, super is taken into account and can be set off against assets, but we don't have the enough information on the site to allow to guide a super split. But we do provide a fair bit of information about it, but it's certainly not something we're giving up on. It is something that we're working on, that functionality, and I would hope that the aim is that we do keep improving Amica, and that is certainly something that's on our list.
Thanks.
And Colin Lancaster, if we could come to your question now, if you can put your mic on.
Yeah, thanks, Richard. And thanks, Gabrielle, really interesting. My question kind of follows on from that previous question, which was really about who the users are and what analysis you've got of the profile of users, and particularly whether they are users who you think would otherwise go through legal aid services, who would otherwise end up in court, or is it drawing in people who might otherwise have paid for a full lawyer service? Or is it people who would otherwise have struggled through? So I'm trying to work out who is coming, and that's the flip side of who's being excluded, I suppose, in terms of the previous question. And is that the profile you expected or wanted to see? And is it something that you are then using to target different users or try and encourage uptake amongst different groups?
Thank you for that question. When we started this project, we wanted to know if we build it, do they even want it? You know, even rather than will they come? And so we did some market research. We used an independent market research company to do some research for us. We had assumed at Legal Aid that those who could afford to pay a legal practitioner, would not be interested in a tool like this. It would be for those, perhaps what we call in Australia, the missing middle, those who can't get a grant of legal aid, but also can't afford a private practitioner. What our market research told us, though, is that right across the board, all sectors of the community were interested in Amica, interested in a tool that they could explore for their own circumstances. And what we're finding with the users is the same thing. It does range right across the board. It was never designed for your client who will qualify for a grant of legal aid, because as I think we all know, many of those clients are very much the pointy end of family law. That was not what it was designed for. What it was designed for those clients who do have a simpler situation and are inclined to settle that situation. But we are finding people that could well afford to go off to private lawyers, and they are using this. But of course, the more complexity you have about your financial situation, your assets, the more you will find you're going to need the help of an accountant or a lawyer to settle things, particularly family trusts and other complexities in relation to property. So it really is the missing middle that are our sort of standard user, but it doesn't exclude either ends of the spectrum.
Thank you, Gabrielle. Miri, are you able to turn on your microphone? Ask your question.
Yes, thank you.
My pleasure.
Hi, thank you so much. I work with UNODC. So as you know, as the UN, we're always interested in universal tools. And my question in the chat was, in your view, would other jurisdictions be able to use Amica with some adaptations, or is it too kind of locally defined? Because the issues you mentioned, regarding children and property, they're universal. So I'm very curious to hear your thoughts on that. Thank you.
Thank you. Yes, we would love to think that this tool could be used universally, but of course it has been designed particularly for Australian family law. The reason why National Legal Aid chose family law is that it's one of the few sort of pieces of legislation in Australia that applies to everybody. It's the same application all around the states and territories in Australia. So it has, for Australia, a very wide impact on people separating. And so that's the law they've got to apply. We have some differences state to state, but not enough to mean that we needed to write perhaps the program differently. And so the principles behind it will apply to everybody who needs to respond to family law in Australia. But the building of the AI to assist with property settlements, of course, is all dependent upon what the courts would decide in a situation. And so if it was to be used universally, there would need to be quite a bit of work done on the local law and, of course, how courts are deciding local disputes. The principles, though, of design, client-centric design, design in consultation with clients, a simple user interface, information at every point along the way, all those principles, I think, are universal.
Thank you.
Thank you very much. Could I ask a question, Gabrielle? I spent quite a bit of time talking to a private provider of something which sounds quite similar in the UK called Amicable. And they tried to essentially build a system which is quite similar in concept to yours. And they discovered two things which drove uptake, they thought. One was really quite detailed qualitative engagement with users around what they liked and what they didn't like. So essentially regular focus groups or one-on-ones with them. But also that actually to persuade people to use the system, they needed to engage through essentially lay advisors on the telephone talking to one side of the couple and then the other about the service before they would trust them enough to come into the system and use it. I wondered if you recognized or used those two types of approach in driving uptake, or if you found other ways of driving uptake.
Thank you. Yes, both interesting things, both things that we have sort of had to deal with and approach. We have developed, because this project is a national legal aid project, we had behind us the provision of early intervention advice and information at every legal aid agency around the country, around Australia. We already provide free legal advice, and many of the commissions or legal aid agencies provide online advice and information. And so what we did is we replicated those avenues for getting further information and having a conversation with a legal advisor in Amica. We have the legal chat called Ask Amica, and many people engage with Ask Amica as they're going through the tool, and then at the conclusion, if they want to ask further questions, perhaps about filing their documents. And so we do find that that does assist many people. What we also found, and everybody who puts a product online also knows this is important, is there are very often technical issues that the user will find as they're going through the tool, and they need to be fixed, and they need to be fixed quickly. What we have found is a very common thing is actually the typing. And so when someone needs to put down how much their house is worth, if they put 4 million instead of 400,000, that of course is going to so severely impact the suggested division of the assets. And so people usually realize it pretty quickly, but then they need to get that sorted so they can sort of get back on track. I would say that one thing that perhaps I didn't mention in the video recording is that we actually have quality control over the suggested divisions. We have family lawyers employed to check each of the suggested divisions before it's released to the user. And so if the division does not appear to be consistent with the information that the users have entered into the system, then we're able to then say that either something's gone wrong with the entry of the data or the circumstances are not suitable for this form of online dispute resolution.
What I'd like to do is broaden. I'd like to broaden the discussion and bring in all four, if we can, to the points raised by Colin and Lindsay. Lindsay, if you could get ready. Colin, I don't know if you're able to come in and ask the question you raised earlier about social media crowdsourcing and so on, and then Lindsay will come to your question maybe straight after that and ask the four to respond to the two questions in any way that they think is useful.
Sure, thanks, Richard. It was really just a point that was sparked by the discussion earlier about fragmentation and, if you like, democratization of online advice, and also sparked by thinking about the current public health situation and the range of misinformation which has been available online, and particularly through social media, and wondering whether that translates over into our area of interest, and if so, how the questions around fragmentation and trust and regulation might be considered when something is almost entirely outside the publicly funded or organized space and is instead informal, peer-based, social media driven. So it's really just putting it out there for comment and consideration.
Thank you. Lindsay, are you able to share your question again, and then we can put it back to our panel? Or your point? Or has he gone? We may have lost Lindsay. So if we get him back, we'll come back to him. But could do the four of you have anything to say about the points Colin was raising? Maybe if I come to you first, Becky, put you in the firing line.
I mean, I think in a jurisdiction like mine, there isn't a central authority that's well trusted. So there's an interesting stream of work done by a woman at Stanford named Margaret Hagan. And so every state of the 50 has a statewide legal aid website, and they maybe get, there are 3 of them, California, Texas, and New York, that get a lot of business, and the rest of them get very little business relative to what we know about how many people have problems. But to your point about social media, she has another part of that project is looking at Reddit, which has a stream of people asking for legal advice from strangers on the internet. And of course, some of that advice is terrible and some of it is good, but she's using it as a wonderful way to learn about how people actually describe their own justice problems so that you can design other kinds of online and computerized providers to respond to the way people actually talk. So I think there are dangers there, obviously, but there are also possibilities for using that information to design our centralized services in better ways.
Thank you, Becky. Who would like to come in?
Well, I would just say, as Colin may well know, what goes around comes around. We used to have a legal services commission, and it used to have a concern for this sort of problem. And it led the drawing up of a set of criteria for websites and otherwise, and it developed a quality assurance tick system, which may be in the back of your mind. and would be possible for you in Scotland. I thought SLAB would have the credibility potentially to be a quality assurance certifier. Whether you actually want to regulate it takes you back around to the issues that Becky, that are so prevalent in the States about regulation laws. You might not want to get so far as a regulator, but the notion of having a quality tick in the UK, that couldn't be government, I don't think, wouldn't be government. Legal aid authority is just an administrative body. There's no strategic lead for legal aid. It could be the Citizens Advice Service, potentially, or it could be somebody set up for the purpose. I suppose it could be the Ministry of Justice, just to reverse what I initially said. Approved by. The critical point in a way would be, well, partly who it certifies, but on what basis. And there are various precedents for that, as Colin will know, I mean, in terms of the freshness of the information when it was updated and so on, had it been approved. I think that's the sort of way forward. In the UK, we're a long way, in England and Wales, we're a long way from being able to do that. In Scotland, you might be much closer. And Wales would produce an interesting issue because it doesn't have a formal body for coordinating legal aid, but it has forces and institutions interested in developing a Welsh approach. So that would be a jurisdiction much like the US states, perhaps, where you might have an informal body that produce some sort of tick system and some criteria.
And it has some quite important separate bodies of law.
Yeah,
Sorry.
Roger, the Welsh have put in a report asking to have their own legal aid. So we'll see what happens to that.
Angelica or Gabrielle, would you like to come in?
If I can perhaps make a comment that when we started our this project, Amica, we did consider what does trust look like for the potential users of our tool. And so we included those questions in our survey of clients. And this was before we started to build it. And what we, at the time, it surprised us, but what the potential users told us is they did trust government websites, such as we have one called MyGov, is where citizens communicate with government, particularly in relation to tax and other services. And so what they said was that really the combination of the Commonwealth government and legal aid was sufficient for them to then trust the outcome or trust the product, but they put it very highly ranked as an influence as to whether they would or would not use the product.
Would you trust the government site on immigration and you know, on the difficult, touchy political issues? Would we trust a government site on immigration and asylum? Would we trust it on equality? Would we trust? You know, I think there are areas where governments are trusted. I would trust it on tax, but I think it's a bit problematic in different areas. Would you trust it on crime?
I think what we have to realise is it's the client's perception of who they trust, as opposed to what we as specialists know, you know, the detail. For them, it's fairly simple. In Australia, anyway, from the survey we've done so far, you know, that was their go-to, was the government sites.
So I think family is a really interesting area because actually Leanne Smith's been doing a lot of work on this, and one of the things she tells me is that a lot of the, if you like, public, in quotes, legal education and information provision and informal advice is provided by parents groups, some of whom have quite strong agendas. So you've got Mumsnet and Only Mums and Only Dads, who, if you like, at the more moderate end of the spectrum, you've got Family Needs Fathers at another end. But those types of groups dominate the provision of advice to large numbers of divorcing or splitting parents in particular. And there ain't no regulating that, really. You kind of have to either live with it or you have to build something better, right? Angelica, would you like to come in, or shall we draw a line?
You should go.
Okay.
I do not have some comments.
Okay, that's great. Well, so we're actually more or less perfectly at time. Alan will be delighted to hear. I'd really like to thank everybody for their presentations and answers and indeed for the audience for some really terrific and insightful questions. Thank you all. Alan, are you able to tell us what happens now? Or is that my job? And I forgot.
Well, I was going to say that we have a break for 15 minutes. Can I remind everybody that if you're going to session 4B, you have to use the alternate link. I'm hoping that there's the link will be coming up in the chat, but otherwise it will be the alternate link, the parallel streams link that you had from your original invitation from Eventbrite. Here it is. There. And we'll see you at 9 o'clock, well, or in quarter of an hour.
Thank you all. Thanks. Terrific session.
Thanks, Richard. Great moderating. Thank you very much. Thanks to all the speakers.